Hello and good afternoon, everyone. So we are now on the second set of discussions on the Data Protection Act. The first one was the broader one around the transition journey, and now we are going into a specific topic around employment. And I think we also did one on notice. No, not on notice. I think on the marketing part, right? So we have so the interesting thing is we're following the same format. We'll have an expert give a presentation on what to look for when we are looking at implementing this law from an employment perspective. And for that we have Gowree Gokhale, who's the TMT partner at Nishith Desai Associates. And Gowree has been working with us. She has been advising us for long in the journey for not only data protection law and a lot of other things. So it'll be good to hear now in the implementation journey, what are her thoughts and basis what she's talking to a lot of our clients and so on and so forth. And then, of course, we have got a couple of very interesting industry experts, and that will really also give us a flavor of what is happening at a firm level, and both not only from a legal perspective, but more from an implementation perspective, that what is it that we should look at and what can be the good practices. So we have Dr. Ruchi Agarwal. She's from Genpact, and she is the Assistant General Counsel and the Data Protection Officer there. And then we have Abha Tiwari from Renault. Renault has a big GCC in India, and again, she's the head of legal and she's the DPO there. So with that, my colleague Priyanshi is the one who is going to be holding the baton on this session. So I'm going to hand it over to her. Over to you, Priyanshi.
Thanks for that, Ashish. Hi, everyone. I will just first lay down what the structure of the conversation is going to be like. Like Ashish mentioned, Gowree will be presenting the Act and how it interacts with employment, and just give an overall view of the DPDPA and employment in India. Then we'll open the floor for questions, and we'll have our experts here, Abha and Ruchi, also give their opening and initial insights into the law. And while that's going on, the attendees are free to post their questions on the chat, and we'll be taking that up. Also, one thing, we are requesting you all to limit your questions to employment in India. The other aspects of the law we have been covering, like prior to this we did on marketing, and there's a webinar tomorrow on GCCs, which will cover a lot of foreign processing. So today we are hoping that the questions are limited to employment. With that, over to you, Gowree.
Thank you for that, Ashish and Priyanshi. And thanks for clarifying that, because otherwise, this 1 hour is not going to be sufficient. So quickly, where are we? Right, it is done. We are waiting for, of course, the month or so they may issue rules in that regard. The next step, of course, is the rules, because there are about 20 odd provisions which relate to us, in terms of industry, because there are other provisions also which affect the board, but about 20 odd provisions where there will be rules issued, where we will know from an implementation perspective. For that, I think some of the industry, as Ashish mentioned, some of our clients, some of the industry members are working on giving feedback to the government as to what should be part of those rules and what should not be part of those rules, right, equally. So that is the next stage, that is, the industry is working on. The minister in the recent, the MOS, which is Rajiv Chandrasekhar, in a recent consultation had mentioned about 6 months from the rules, from an implementation perspective. The industry feedback is that is not going to be sufficient. Even if you do a phase-wise manner, the pushback is about 18 to 24 months. That is the general feedback that we are hearing, just like we had in GDPR, right? The next quick thing is, the feedback from the ministry side is that if you are GDPR compliant, you should not take so much time to comply with this law. But the counter to that is no, there are differences. As we'll go along and see, there are differences, and it's going to take time, right? So that's from an implementation journey. So all of you, in my view, and you will realize today, there are so many areas, forget the rules, even on the act, there are so many areas where we need still clarity, right? And I will show you some of those questions. So our feedback to the government should be that please give us clarity, please issue FAQs, let us have industry consultation even on that part, so that everybody is clear, because unless everybody has clarity, you will, and the important part is most of this processes that you will need to set up internal are going to be automated. That means recoding, coding, change of architecture, etc. If you have done that and thereafter the government says, no, this is what we understand this act, or this provision to mean in this manner, to be interpreted, I mean, the entire effort goes waste, right? So that clarity is important both from the act and the rules. So with that, let us see, what really is this act doing. This act is doing essentially, 3-4 main things. It is defining the overall ambit, and let me share my screen. Give me a second. And I may, tend to speak very fast because we have limited time. So bear with me. So basically what is happening here is the applicability, right? It applies only to personal information. Personal information is defined to mean any data about an individual who is identifiable by or in relation to such a data. Obviously, anonymized data should not, get included here at all. So that is out of the window. But, the questions get asked that, okay, if it is device related information without identifying a person, then what happens, right? But I mean, those open-ended areas remain. But today, since we are talking about employee data, I will not deliberate on that, but those questions remain. The next thing is the digitized data only is included in this. So if you're collecting physically, but even digitizing thereafter, the act will apply. Extraterritorial applicability, yes, there is an applicability extraterritorial as well, but because you're talking about employee data, I'll explain to you in a context when we come to that. If you have offshore entities, right, in your group, and they are going to process Indian data, then when will it still apply? We will discuss that. Then there are certain exclusions, for example, publicly available information. Just to give an example, when you are doing in the employment context, when you're doing background search of a person, and you're checking their Facebook account, right, or whatever, right, their social media accounts or whatever. So the data made available on those accounts, technically that is outside the window, of this particular applicability. Just putting that in the context of employment. Then research and all, I think that's not that relevant, but there are certain exclusions for research, and even state government have their exclusions as well. Now, what are the grounds of processing? When we say grounds, that what is the basis on which you're processing? Now, the word processing itself is extremely important. People don't realize the ambit of processing, right? So we would request you to, read that definition word by word, because the storage itself is processing. People don't realize that, right? So if you're storing and you're not erasing, you're still processing that by just storing it. And there is an obligation of erasure. We'll come to that, but therefore, please see what does processing mean, because the transfer to the other party also is processing, right? So that is extremely important, and therefore, whatever activities we are undertaking in that context, what are the compliances, right? So there is a consent-based processing, and then there is a legitimate purpose processing. When you say consent-based, it's very straightforward. You're trying to take a consent for the purpose for which you're going to process the data. But for an employment purpose, there is an exclusion. That means if you're going to process the data for employment purpose, then you don't need to take the consent, right? Or and in relation to that, obviously give notice, right? Then there are exemptions also for the applicability of the act itself, which is for legal processing. Suppose you have an employee, dispute, right? And there is some processing relating to that dispute, or, you are either claiming the right or employee is claiming the right, and that right is getting litigated. In that context, if there is processing, consent, is not required. Of course, the act itself doesn't apply, right? Except the security provisions in relation to act. So what do we need to therefore test? That whatever the processing activity you're undertaking, is it falling under legitimate purpose, or is it falling under any other exemption under the act? If not, then you have to obtain consent, even if it is employee data. Because there is a misconception that if it is employee data, then notice consent not required. That is not the case. Only if you fall in these exemptions, only then the notice consent not required. Otherwise, you need to take the notice and consent, right? So that is why the consent base. So you will need to draw those circles, do the Venn diagrams, and figure out where your data sets fall when you're doing that data mapping exercise in the organization, right? And thereafter, take a decision. So let us see what does the exemption say. It says for the purpose of employment. The first question is that if I'm assessing a candidate, he's yet not my employee, correct? So does it mean for the purpose of employment? These are the questions you have to tell the government to issue the FAQ on, in my personal view, because then otherwise the purpose of this, requirement will not be solved, right? That you will be collecting information, you will be collecting background checks because you want to do those, you want to, have an employee who's thoroughly checked. So can we then go and take consent that, I'm going to take consent and then do that, background check? Seems a little odd, right? So therefore, when you say for the purpose of employment, it should be a wider ambit, is my personal view. That should be the approach for this. Then or it says those relating to safeguarding of the employer from the loss or liability. And they have given, for example, corporate espionage or maintenance of your confidential information. So if these are the purposes, then there is an exemption for notice and notice and consent, right? So therefore that becomes your legitimate purpose for which you don't need notice and consent, right? But all other provisions apply. We'll come to that. And provision of any service or benefit sought by the data principle. For example, if you're giving a medical benefit, you're giving ESOPs or some of those other activities, right? In relation to that, if you're providing any service, for example, you're giving, say, free gym membership or free whatever, and the employee is aware, availing that particular benefit, then for that purpose also you don't need notice and consent, right? So that is these are the buckets within which you need to examine whether your processing falls. So let us see what the questions are. Who is an employee? In the IT sector, it is not uncommon, and I'm sure Ruchi and Abha will throw some more light on this, that to identify whether an individual is employee or not itself is a question mark, because sometimes you have consultants, sometimes you have contract labor arrangement, right? So who is in an employer-employee relationship has to be understood to avail the benefit. If you're not able to avail the benefit, notice and consent applies, straightforward, right? Then what about dependents? Now, so many times your employees, dependents are getting the benefits from your organization, for example, insurance cover, right? So in that context, then, obviously there is no employer-employee relationship, and therefore this exemption should not apply to those individuals, right? So that is the other point. What is the employment purpose? That itself, needs to be understood. For example, hiring itself, right? Retention. Then suppose employee exits. After that, can you say that the purpose is complete and therefore you need to erase after that? Or, the feedback, for example, from the IT sector, we had received that once the employee leaves, they apply after 3-4 years. And if we don't have the record, and if they, and if they were not satisfied with them, right? How do we tally it back that, whether the same person is coming back after 3-4 years? How do we know that? So this is the question that often get raised, in the IT sector, right? Because you have thousands and thousands of employees. So what is that employment purpose? What is the reasonable time for which you can keep that data? That itself, is a question mark. I know I may be asking more questions than answering, but, this is what we need to identify as to how are you going to define the employment purpose in your employee policies and all of that as well, right? And provision of service, I think I have already given an example. Now, so if you're falling under this category, right, of this particular processing, then the notice and consent doesn't apply. But if you don't have clarity, whether is that employment purpose, whether is this not, then the only additional thing that you need to do is notice and consent. So sometimes the view that the organization can take that in any case, let me give notice and consent and be done with, right, to identify those purposes rather than debating whether or not it is employment purpose, right? Sometimes organizations do take that approach, and internationally also they said, any case I'm doing notice and consent, then might as well do it. Of course, GDPR is slightly different in this regard. Then when no exemption applies, as I said, I've already given that, clarification. The most important part for most of you will be the past data that has been collected, because Section 5.2 deals with the past data, and past data is something, if you have not taken consent for processing, and if you're not falling in that exemption, as I mentioned, then you need to give notice of your processing, and the notice needs to specify, the purpose was for which you're processing, etc., etc. And then if the consent is, if they don't withdraw the consent, right, or they say that don't continue with my processing, then you will have to discontinue processing, right? And of course, if you are not allowed to continue processing, you can say that, that is a condition of my employment, and you may be required to, if you terminate, that will not be viewed as as a negative thing, because that is what the act clarifies as well. So, quickly on a data fiduciary, who's a data fiduciary is a person who determines the purpose and means of processing, right? So all the employers will be the data fiduciaries. Sometimes you exchange data with your, with your group companies for some other processing, right? Those may not be treated as data fiduciaries. Those may be treated as your processors, right? And the obligation of a data fiduciary, it continues under the act, and even if processed by third parties, and you're liable as data fiduciary for the processing by third parties. So the third parties don't have a direct kind of penalties under the act. It's the fiduciary who's in the first line of defense, right? So your contracts with the processors have to be structured in that manner as well. And Priyanshi, you please keep me honest on time, because there is a lot to cover, but I'm just going to run fast after this. So, obviously, you need to have security standards, you have to ensure accuracy and fairness of data. There are a host of these other obligations. So you need to study what an obligation of a data fiduciary is and set your processes in that regard. One important thing is data breach. In case of a data breach, and we get this question constantly, the board will have to be informed, which will be set up, as I said, as well as each and every employee whose data has been breached will have to be informed in addition to the board. Right. So these are the, some of the obligations, and I'm going to share this slide hereafter, so you can quickly look at that. Then you have the data principal rights. The most important rights are right of correction, completion, etc. So you need to inform the data principals of their rights. That is the data subjects, as is generally known, the terminology. So those data principals will have to be given an option to correct their data, update their data, etc., etc. And then, obviously a right of grievance redressal. For example, if they feel that your processing is not as per law, you have breached, or there have been breaches, but you have not informed me. So any of these, there is a grievance redressal process that has been specified. So as a takeaway from all of this, you need to revisit your employment contracts, policies, practices, to ensure compliance as and when we get full clarity on the rules and the act. As I said, retention, you can retain the data only in accordance with the act after your purpose is complete. You'll have to delete that data unless, of course, you need to retain that for the 3 purposes that we discussed before under section 7. But other than that, only under the applicable law. For example, some of the employment laws need to retain the data 3 to 5 years. Tax law may require you to retain, for additional purposes, but not all the data sets. Only those are required under the act, those relevant acts. Those data sets you may be allowed to retain, even if the employment purpose is complete, right? Even then, if the law requires you, you may retain that data. Some of these examples, quickly, for example, this is very common question that, all our data sets of employee are handled in one location outside the country, right? The IT companies have these group structures. So then, is that processing abroad covered by section 7? Because it is employment purpose, right? But the transfer or sharing itself, it amounts to processing, right? So, therefore, these questions, the other interesting question we had is ESOPs are granted by the foreign entity to the employees of the Indian entity. Who is the data fiduciary? Are both the data fiduciaries? Only one entity is a data fiduciary, right? So you need to see all your internal contracts, how they are structured, identify who the fiduciary is, because that is where the obligation lies. And accordingly, you will need to structure, all your internal arrangements. I think I have discussed this already, limited exemptions on legal obligation on the basis of obligations, etc. Transfer, this question is also common. Maybe this is the last slide. The transfer essentially is where you're transferring the data from India to foreign country. The government may come out with a negative list of countries where you will not be allowed to transfer the data. There is no clarity if the processing is already being undertaken under those countries. In those countries, then what happens? I suspect that you will have to, redo the entire arrangement. You will have to store it elsewhere. You will not be allowed to continue to process in those countries which may appear in the negative list. The grievance redressal I have already mentioned. Of course, there are fines. Unfortunately, the fines, they are not pegging towards the revenue, as such of the entities. They are putting just the broad numbers. So the feedback from the industry is that the board should come out with some kind of system whereby they can give some indications of the numbers in case of certain types of breaches. Of course, they'll have to take certain facts into account. Was it was there a negligence, no negligence, some other, the actual impact of the breach, etc., etc. Basis that, some of these penalties will get applicable. So I think this is a quick overview, but, we do have another, 45 minutes or so to do question answer, and I'll share the slides and back to you, Priyanshi. I'm sure, there are other elements which I could have covered, but maybe those can get covered in the question answer.
Yeah, thank you so much for this, Gowree. This is extremely exhaustive, and I think it establishes the base quite well. Next, Abha, Ruchi, I would like to call you for any initial remarks on your experience that you have had in other jurisdictions and what you think the industry should be looking at next steps in terms of employment now. Over to you.
Hi. So, Gowree, thank you for covering a lot of questions because, as we had DPDP Act coming in, and then the first question was, who all does it apply and how much of data are we sitting with? And this is when we realized that the employee data, and I would not use the word employee, and forgive me for that, I would use the word somebody who's working or somebody who's engaged with, because uh, there is an interest that the organization has. And if I may break this down, there are 4 points. One, the organization is definitely interested in protecting its resources, such as those that are covered under the Act: confidentiality, trade secrets, IP rights, etc. The organization also has the obligation to provide safety at workspaces. And when we look at the definition of workspaces, it's not just the physical workspaces where people live or people stay or where people work, but safety in the sense that this data is being transmitted across jurisdictions, if not cross-border, like in India. So pre-COVID times, when everybody would come to work, there was this corporate fence that was drawn. The corporate security, the IT security was there. Now this has extended. Now we have people working from home, people working from remote locations, which also means that the space, the corporate space or the workspace that we call, has been stretched, and this needs to be protected because this is where a lot of data is getting transmitted, including the employee data or the data which is required for organizations to function. Not to forget that we are sort of looking at automating, we are looking at enhancing productivity, we are looking at optimizing resources. And this brings us to the second question, that is, there are a lot of tools that have come up in the sense of employment. Let's say we had something which said there are tools, they are artificial intelligence backed tools, and they can help us screen candidates. And these tools are developed with a lot of data that has gone in, but the results are that in many cases, and in almost all cases, there are proven biases. Now, how do they impact the whole ecosystem of employment? Data sets used to train models, models deployed by organizations, which, and we have known cases in different jurisdictions where lawsuits have been filed. Now, while screening candidates or in the course of employment, it has been discovered or it has been found that there are inherent biases. And then these biases directly have an implication on the right of livelihood, the opportunity of employment, discrimination, and all that comes in. Second, as Gowree had mentioned, that the concept or the context of employment is, if we are understanding like the plain terms, it is where there is an employment contract, employer, employee, sorted. But it's not as simple. It begins with the fact that a CV gets sourced from somewhere, including directly on the website. This is where the employment context does not exist, but the data is being processed. Now, if you look at the rights that are granted under DPDP, even if you were to say that this is a data principle, but this data principle has all the rights that are granted under DPDP. However, it is upon the organizations to ensure that this is carried out or this is effected throughout the life cycle. Like there could be candidates who will be taken in, there could be unsuccessful candidates. Organizations also have the propensity to keep the data for a certain while because they would go back and look at this data pool. Background checks that are conducted. During background checks, a lot of data of other people gets processed. So ex-bosses, colleagues, peers, right? Emergency contact details that are provided. And these are very essential, very basic. These emergency contact details are kept in the system for fairly long. Many times it also happens that, let's say, if a notice was required to be provided to a prospective candidate, the candidate had yet to join in, but the name of the organization is confidential because let's say it's a strategic hiring. So the candidate, on the other hand, may only know that okay, it's a tech company or a pharma company or something like that, but they will never know against who's processing and who's collecting the data, right? In the course of employment. Now, while we have DPDP, which says that data subjects, and I'm talking about specific circumstances where data gets processed by call centers, voice samples. We keep it for quality and a lot of other purposes. Now, there is a data subject, a customer who comes up and says, I would want to have access of the data that you have, let's say a call recording. This call recording also has a data which is of the employee who's perhaps participated in that conversation. Now, if a data subject's right has to be excised, it should in all fairness be such that it does not end up violating the right of another principally a data subject, but an employee in this case, right? And then once the employment comes to an end for various reasons. Now, when the employment comes to an end, there is a certain period for which the data has to be retained. Then there are certain legitimate interests for which the data will have to be kept, because there could be an employment, and like Gowree has given that example that somebody could come up after 4 years, and they might just the employer, the organization would be interested in knowing whether they could take this candidate back or not. How should this data be kept, and where should this data be kept? Another point that I wanted to share is that this is when there is a context of employment. Other cases where there are indirect employments, where there's a deployment through a manpower service providers. There are interns, there are consultants who work in the organization. So currently, we do not have a framework, or it is not really clear of how this has to be processed. And then we also should not forget that workspaces, the platform workers. So if we look at them, they don't directly fall in the ambit of employment. Perhaps they will not be covered in the 7I section that we're talking about. It will not even apply to them. In many jurisdictions, there are claims where they say, on one hand, the employer is sort of determining the work time, the employer is sort of determining, or the organization, the platform organization is sort of determining what could be the restrictions, what could be the timeline, what could be the grading mechanism, etc. At the other hand, the candidate who's choosing to work with these platforms is free to, or it appears to be that they can freelance with these digital platforms. These digital platforms, and they deploy algorithms. Algorithmic decision making continues to be one of the challenges that plagues the whole system, and this is worldwide, in a lot of jurisdictions. Many jurisdictions, in fact, some of them have said that technically an employer-employee relationship is coming into picture here too. This again is currently not covered in the space. How will this be covered? We'll have to wait and see if there could be rules around this, or there'll be another set of regulations.
Thanks, Priyanshi. I would like to start by thanking NASScom for inviting me for this panel discussion and this webinar. This is an important topic, and you must have heard from our co-panelists, Gowree and Abha. I'll just add to what they were saying, and I'll touch upon two major issues over here first. First is the difference of what the organizations can decide whether they need to process the employee data under the consent regime or whether they will take it under the legitimate use, basically. So that's a big decision which the organizations have to make as for today. And I'm sure all of our member companies would be on some path of implementation, and they would be crystallizing in their mind as to what are the next steps on implementation. And this decision would be taking the center stage. Obviously, employee data is crucial for every organization. So having said that, there are certain practical aspects or certain points of consideration which the organizations have to think over before taking this decision, to my mind. Like, for example, one is whether a consent was taken earlier under the existing SPDI rules or not. That will also be one of the determinant factors for organization, because as you know, for employment purposes, there is quite a lot of sensitive personal information which is collected under the definition of the SPDI rules itself. So do organizations continue with that consent itself, or they discontinue the consent regime and go over to the legitimate use purpose? Second aspect which I would like to bring over here is that if the organizations are taking the legitimate use, how is employment purpose defined? Gowree well mentioned that as well, because employment purposes, what are employment purposes? Like in our organization and in many organizations today, it is not only purely restrictive to the employment, disbursing salary, considering the statutory benefits, etc. Not only that, organizations does a lot of analytics as well basis the data. They collect the time sheets, basically how much time a person is taking to process a SR or anything of that sort. Then the optimization comes into picture. People do decide on the basis of this data itself how the optimization can be done. They evaluate engagement scores of the employees to give them the best employment environment in the organization. There are analytics being done on that, and these are through various statistical rules and tools and algorithms and the AI now into picture as well, as Abha was mentioning. So would all these purposes, I would say ancillary purposes, which are not pure employment purposes, would be considered as employment purposes? To my mind, as of now, we do not have a definitive answer, but yes, they won't be. Then secondly, the part about that, if the organizations goes around taking the ground of processing as the legitimate use, then they can continue to process the data even after the consent is withdrawn. Will that work? Yes, to my mind, it will work. But again, we will have to see that it is within any other law which is allowing us to process that data. Because until and unless that is there, so no ancillary purposes organizations will be able to process the data on, basically after the purpose is fulfilled, even after the engagement of that particular resource is discontinued with the organization. So these are certain practical considerations while the organizations are deciding on this very, very crucial thing around consent versus legitimate use. Then second part, which I would like to bring about, and Gowree and Abha also touched upon this, is the BGC of the candidates. Now, to my mind, in strict interpretation, employment starts from the date of the contract itself between the resource and the organization. It is not there at a candidature state. If we are evaluating a resource for employment purposes, whether he can be or she can be taken as an employee, that doesn't mean that there is an employee-employer relationship which is existing at that stage. And hence, organizations have to really demarcate those two processes. To me, one other practical aspect over here is like the success ratio of these interviews itself. We process the data like 100 candidates, but only 70 might be taken as employees itself. So your 30 is again a delta, basically, for which there is no employer-employee relationship which is created. Hence, I would suggest, and to my mind, I think that these two stages has to be demarcated, and there has to be a system of control in place where the employer-employee relationship is existing. Then you go under the consent or the legitimate use purpose. Otherwise, for candidature, for evaluating the candidature, to my mind, it has to be a consent-based approach which has to be taken. Then another thing which I wanted to bring about is, and Gowree mentioned this, that what about processing of data even after the employee-employee relationship discontinues? The act is allowing the organizations to process the data if it is needed by any other law, the prevailing law. But what about the other purposes? Like, for example, we receive requests from the employees, from the ex-employees, after 3-4 years for visa purposes, they need a job description, they need certificate. This is not under any law. These are practical aspects which we need to consider, which organizations will have to consider. Priyanshi, these were some of the bits which I wanted to talk about.
Yeah, thank you so much, Ruchi and Abha, for that. So we'll just start taking questions from the chat that we've been getting. I think one major question has been on a withdrawal of consent, that I know we briefly touched upon this through the presentation and through your initial insights, but if we could expand on how consent withdrawal would work. And I think here it would also make sense to talk about how rights will interact, like right to correction, erasure, and access, etc. So anything on that?
So I think, the Act itself has specific provisions, but, the entire method and the process as to how the data subjects can exercise their rights will come more detail in the rules. So if anybody has any feedback, you should collate that and hand it over to nasscom to give that feedback, how to ease the process. But if you see, section 8.7, and, the reason I'm calling out sections here, because I feel that all of us should read, it word by word. So there they talk about the erasure. Now it's very interesting that, the legitimate purpose that all of us have been talking about, it is not a consent-based processing, right? But it also has a reference. So it says that fiduciary shall, unless retention is necessary for the compliance with any other law. That's what I mentioned. Some of the laws do allow you to process or require to process also, right? When it says necessary, so allowance is not the, it's more of necessity under the law that you need processing. It says you need to sort of, erase personal data upon data principal withdrawing the consent. The way I'm reading this provision applies only when the processing was consent based, right? But it goes on to say that, or as soon as it is reasonable to assume that the specified purpose is no longer being served, whichever is earlier. So when you're going under the legitimate purpose, you will fall under the second category. If your processing is not consent based. So if that purpose, the employment purpose or whatever we discussed, on that slide, if that is complete, then you require to erase it, right? And it says, and causes, and not only you erase it, let's be very clear that your data processors also erase it. So that's the level to which you have to go, right? So your data processors, maybe 10 data processors or whoever, and we are talking about, let's understand this, right? It will all have to be automated. Somehow you need to put some logic in your systems, because you're handling thousands of employees. For every employee now, you're not going to figure out, okay, for this, what is happening. Then which processors, because you will have processors who have, sort of have processed your data over a period of time. So you'll have to, sort of have a system in place that what are those logics built in your system where processor is deleting back to back, right? So I think let's be very clear that once the consent is withdrawn, or if your processing is purpose is complete, you cannot retain unless it is necessary under law. Let's understand the word necessary, right? So hope that is clear. Priyanshi, quite a few questions I've answered there and then, while Abha and Ruchi were speaking. In
Yes.
short, yeah. So you may skip those questions.
Yes,
Hopefully, yeah, because there are quite a few now.
Yeah, we've taken a note of that. Other question that we've seen are on third-party tools that the industry uses to store data. So the question is, if you're using third-party tools for storing data or any payroll application, and then there's a violation or leak from there, then who will be liable in that case?
Obviously, Data Fiduciary have made it very clear, whether we like it or not, under the Act. Even if you see the breach related provisions, everything, the first line of attack is on fiduciaries. You can have back-to-back contract because that is your contractual relief vis-a-vis the data processor. And that is why, insurance and all these things you need to start looking into. There are insurances made available now in India as well, which I'm sure, Abha and Ruchi can throw more light on. But you will need to safeguard your risk accordingly, because the penalty numbers at least are very high. Whether that will be levied or not, we don't know. But if you ask any person to categorize your risk, right, it will be coming to you, and therefore, you need to calibrate that risk and accordingly manage it. So data processor, unfortunately, is not liable under the Act.
If I may just add, so this is where it becomes very important to evaluate all the third parties that you work with. A very important question that comes around, and this is something that we work with a lot of partners, and I'm using a neutral term because they also can be data fiduciaries, they may be processors. So one, please identify whether the parties with who the data is being shared, are they partners, or are they like independently determining the means and purpose of processing, together determining the means and purpose of processing, or they are ancillary, they are processing this data on your instruction. Second, we have, like, again, it'll entail a certain cost, it'll entail a certain compliance, but the vendor evaluation program to understand their capabilities, or I would put it this way. So considering that the Act says that the data fiduciaries are going to be responsible and the penalties will be handed out to them, to what I have seen so far, when we go around to get the contractual obligations interpreted in the court or where a dispute arises and howsoever, it is going to take a while. And it again entails a lot of cost and a lot of energy that goes in interpreting contracts. A step ahead of that could be assess the data that you're going to transfer. Do a risk evaluation, map the sensitivities of the data. Now, I am conscious of the fact that the Act does not have a differentiation, in the category of data. However, different data sets could have different implications. I'm sure and I'm confident that you will have the same amount of penalty. But let's not forget that once a harm arises to the data subject, the board may still be empowered and they may still direct the data fiduciaries to take additional steps in order to mitigate those losses. So one of the best ways that comes to my mind is vendor, the processor, the third party who's going to be responsible, who's going to process this data for you, ensure that they are audited, they follow a certain industry standard. So at least you're able to take the benefit of the fact that they have a certain standard, or you have done your due diligence ahead of it. Maybe it could help in minimizing the amount of penalty that could come in. Also, build in the mechanisms to say or to ensure that if not equivalent, at least a certain, or it is easier for you to exercise your right of right to get back a certain monetary benefit or whatever that could not benefit exactly, but the loss that you would be incurring. And as Gowree said, cyber insurance on breach is extremely important. So there are a couple of vendors. So the subject is evolving. There are vendors who are coming up, and maybe it's time that we look at all of them to understand what best can safeguard us.
Just one more layer to this, Priyanshi, sorry. I would like to add that the organizations have to look at breach notification obligation as well. If you are data fiduciary, you will have to notify DPB in a certain time, and that will be a prescribed timeline. But if you are asking your data processor to process that data and certain breach has happened at that end of the data principles of your data principles, then that breach notification has to be back to back, basically. So you will have to build in that particular obligation in your engagements with your vendors and data processors.
Maybe can I just ask a quick question? So one thing from the audience point of view, I think is the takeaway is that there are a lot of questions which even our experts have today. So if you have similar questions, then probably you don't have to feel that worried, because then you can align yourself with the fact that these are larger questions which a lot of people in the industry are facing. So that should be some ease to you. But having said that, and then Gowree, as you mentioned initially, that there are certain things where we are looking at guidances, right? And this is also something that nasscom has pitched to the government, that you should release those. But today there is none. So even the rules are not here. So if I were to ask each of you, in today's state, what are the 3-4 things that, let's say, I'll start with maybe Ruchi and then Abha and then Gowree, is that what are the 3-4 activities that you are today doing, which will help you in this compliance journey? And which is something that industry largely can then try and see if they want to take that forward. So I think this is the first question, and then I'll come to one more question. So maybe we'll start with you, Ruchi.
So Ashish, I can talk about it for hours together, but just 3-4, because you've restricted it to us like that. So very first thing is what we are doing is assessing where all the personal data is collected and processed. So we have mapped out various streams where the personal data is being collected and processed. And then a very exhaustive data mapping exercises to start, basically, because without the data mapping exercise, we will not be able to cater to the various obligations which we have from the Act itself. Like, for example, DSR, if there is a right to erasure, which is exercised by the data principle, how do we erase the data? Where all do we need to erase the data? So data mapping exercise becomes very, very crucial and the basis of everything. Then on the policy perspective and the policy and the procedures perspective, we'll have to build employee grievance mechanism, because that's also one of the major tasks which the Act is talking about. It has to be implemented, or it has to be mentioned in the notice as well as in the consent. So that's another feature which the organizations have to work on at, I think, in the initial stages itself, because once the Act will be implemented, the notice and the consent will become the very first thing to be implemented, basically. So that's the second piece, I would say. Then third bucket, which we were just talking about, is vendor engagements. So India being one of, for my organization, India being one of the largest service delivery centers, basically, regions, basically. So we amass a lot of data. There is a whole lot of contract labors which we engage, and there's a whole lot of employees which we engage. So there has to be a demarcation. As of now, as we were talking about, that there are no specific obligations in the Act which are for the data processors. Data Fiduciary has the onus of everything, and hence there has to be back-to-back arrangements. So re-looking at those vendor engagements, re-looking at those tools, basically conducting the DPIAs is another part of it. So I'll stop over here, Ashish. I can go on for hours on this. I'll let Abha and Gowree add to this.
Oh, thanks, very good. And Abha, just if you have newer points, I think that will be valuable. Yeah.
Yes. So Ashish, and if I may ask some of us this one question: when was the last time that we, sat on and looked at the data and we said, "Oh, let us trash this amount of data because this data is no longer necessary"? Because we never had, or at least to whoever I've spoken to so far tells me that in all our systems we are sitting on tons and tons of data. How much of relevance do they hold today? More particularly, the sales and marketing organizations, we love doing analytics. While we understand, the life cycle of a data or the data set that could be used for converting a prospect into a customer could range from, say, 3-4 days to maybe 6 months or a year. But then we also have data which was collected in 2000. So one step, please trash all the data that we don't require. Second, while we are conducting or we are trying to build in to do this data mapping exercise, which Ruchi, you rightly pointed out, to identify what are the sources, data points that the data flows in, there's another tendency. We need this too, we need this too, we need this too. And what is the purpose? Just to meet one obligation. So there's a lot of data which is coming from different sources, and this data has very limited purpose. So see if you can minimize as much as, so you can stop, you can filter out the data that is not necessary. And lastly, are we mapping? Look, there has to be a purpose, right, for the data for which it was collected. So there has to be a purpose, and this purpose has to be definite and defined. It can't be in the future I might need it, so let me just collect it. So just to add on to what Ruchi was saying, this is like this we are doing, and we're also looking at what is the retention period that you need it for. What is the highest? It can't be infinity. So let us come to a number and say this is the date, this is the timeline, that this is what has to be defined. So while the framework is still to come, and let's see how we do it there, but then these are some other steps that are being done.
Thanks. And Gowree, you must have spoken to so many of your clients and industry. So what are the 2-3 things they can actually do today from your perspective?
I think first, I mean, before all the steps that Abha and Ruchi mentioned, I feel awareness creation, internal workshops with different stakeholders to walk them through what it means. Because when you're collecting information from data mapping, unless they understand why are you asking questions and what are your questions, because otherwise each department will get one questionnaire without realizing the relevance of that. So that awareness creation in my mind is a must, because we are realizing that there is not enough awareness, across different stakeholders. The other thing is, from a policy perspective, all these things, right? We should all participate in getting the clarification. So if we are able to collect the questions, right? What are the questions that the organizations have? If that also can be done parallelly and share it with industry bodies such as yours, I think that itself, could help us going forward. So that's the second activity. The third activity, I think I echo, what both of them said, but I'll, sort of add a couple of additional perspectives is, start identifying. I got a question here as to which other laws apply to you, right? And under what type of processing is necessary. That needs to be clearly identified, because your systems will have to have an automated processes for deletion, right? You are not going to sit on one data set and figure that out. So that mapping against other laws, what data sets are required, which law applies to me, what data sets under that, and thereafter, that erasure requirement, right? So that logic will have to be built in. And as Abha said, but I just want to go one step further, start drafting your internal notices and consents, which clearly articulate purpose. You will get more clarity as the rules come out, but the organizations will have to start drafting those things. And the fourth thing is, which I briefly mentioned, is the data sets of third parties who are not your employees that you're collecting. The dependents, right? Children, parents, spouses, partners, whatever. And then what is the process that you have for that? Because for that data set, if you want to continue to use or whatever, there actually you'll have to go and take consents, unfortunately, right? And the past data will have to be erased. So if you can start cleaning up, the last point, if you can start cleaning up, please do that. That will help you, for the fast implementation. That's it. I mean, there are many more. For the time being, that's it.
No, that's very useful. And just last question from my side too, and this I'll just put it to both Abha and Ruchi, maybe more from an industry implementation point of view, that see, both of you are also implementing GDPR and you have had that experience as organizations. And given we are on this narrow topic of employee data, then for somebody like you, from given our law, just in terms of how much time and effort and what we need to do to make this part of the compliance with the law. Just want to get a very headline level thing, that is it a fairly familiar exercise in that sense? And while it needs awareness and all of that, are you walking a comfortable zone, or is it so remarkably different that it's pretty much like looking at a different law altogether? So maybe Abha first and then Ruchi. Yeah.
Hi. So it's not okay. privacy law, we all got introduced to sort of in a very structured manner with GDPR. So in that sense, it is not new. It's not new. So we sort of know that, okay, this can happen, this can happen, this is what we are dealing with. But if you look at the act, very basic example, the amount of or the basis that we had for processing in GDPR is not the same. It's not even close to the same. Consent preferred basis under GDPR, and the highest, I mean, one of the most, that's strongest basis on which we have to base our processing. In the employment context, if I go outside of India, Europe, can an employee consent to processing of data with an employer? They're surely they are not on the same footing. Contract law will never allow us to do that. But the fact is that DPDP requires us to implement it. It is consent based unless you're able to fall in one of the exemptions that we just discussed in the whole session. So, and the context of employment is very wide. Work councils are not there in the country where you could have a proposal, go have a discussion with them, and then you come to a certain conclusion, and you're sure about that, if this gets implemented, these are going to be the consequences. So when I said familiarity is there, but this is very different. And if you're asking for the timeline, I think from the time that we have the full clarity where the rules are there and we exactly know what needs to be implemented and how it has to be implemented, what we have been listening so far, gathering from all different sources, 6 months. 6 months is going to be very, very short. Let's not forget that all this while we also have been collecting and processing a lot of data, and we have never had the opportunity of filtering it and identifying different bases. We can do it like prospective data, let's deal it in a certain manner, but the data that we're already sitting with allow us some more time. So 6-8 months is a very short time. I mean, we also will have to adapt our systems, our technologies, and not just ours, to all our suppliers, all our partners, and there'll have to be a certain level of integration that has to happen. There's a certain level of understanding or certain level of benchmarking where a stage where we have to arrive, when we could actually say that, all right, now is the time, or this is the stage where this is where we can look forward to from a compliance standpoint. So there's a lot of work that has to be done on this.
I would echo what Abha said, because GDPR gives much more flexibility from the basis of processing, Ashish, to my mind. There are basis of processing under the legitimate purposes which can be taken up, and hence consent has not been introduced too much, basically, because many of the organizations are using those legitimate purposes grounds for processing. In India, we are not left with much choice over here, because yes, employment purpose is there as a legitimate use, but how much can we use it? In what all scenarios can we use it, is, as we were discussing it earlier as well, we need to see. So just to implement the consent regime itself will take, and organizations with vast employee workforce will have to have like systems in place, because collecting specified purpose based consent is difficult to roll out, first of all, and then administering the whole consent basis, mapping it. If the person has left, then it has to be erased, etc., etc. The systems has to be built in that manner. Hence, I don't see that 6 months is the timeline which organizations like ours can really gear up and implement the DPDP to its true sense.
Thanks so much, Ruchi and Abha, for that. That was really helpful. Other question that we've had and we haven't touched, I think we will take the last one here, is on SDFs. So can a company be considered an SDF based on the quantity and the type of employment data that they have? So Gowree, this one's for you.
Nobody knows. So the government will come out with the rules, on all this, as to what, who will be considered as SDF, because they do talk about volume and sensitivity of personal data processed, right? And when you say, it says volume and sensitivity, so is it not or in that? So I don't know whether the government will go with that, but sheer volume itself is a ground for categorization. So there is a possibility. Sorry, one thing we have not mentioned, and maybe it may apply to some of the participants, is there is a possibility of exemption either completely or, longer term, available for implementation for startups and MSMEs. So that is another area where I think people need to work on to get that exemption, if at all, because most of them may not have implemented GDPR. We see that even SPDI rules have not been implemented, unfortunately. So I thought I'll just quickly clarify that. But yes, volume itself is one of the areas, and sensitivity, I'm sure, most of them may be collecting medical information. Financial information is typically considered as sensitive, right, as per even the precedent law that we had. So there is a possibility that the volume itself will land you in a SDF category.
All right, so I think we are at the end of this particular webinar. I started with the impression that this will be a cakewalk in terms of it's a very limited employment related thing, and then clearly it is not. So so if as a audience, if you were thinking it's very easy to implement the employment piece, then I think it's good to start engaging even more and start taking the first set of steps which our expert panelists outlined. And there is obviously a lot more that we will be able to do once we have the rules. Thank you, Gowree, for coming and making that presentation, and also for answering a lot of questions on the Q&A on the fly. So that's really helpful. And of course, for Ruchi and Abha, I think it's a good to hear your thoughts in terms of the implementation steps that you are actually already putting in place. And for our audience, reach out to us. We are happy to connect you in smaller calls with industry folks who are more reflecting your particular business model and use case, so that you have a better sense of what is happening in this sector. And this is a conversation that we will continue to take up. And a lot of the feedback that we are getting in this webinar and also the earlier ones, we are collating. So we'll be reaching out to the government as first set. We'll be reaching out probably next week itself to give them some sense of how the industry is faring in terms of their own initial steps of looking at implementation of the law, and whatever are the kind of, the key challenges, we'll be flagging them off. So keep this conversation going, write into us directly. I think my colleagues have already put down the email ID here. So again, thank you very much, Gowree, Ruchi, and Abha, and of course for Priyanshi for moderating this, and Varun for all the backend silent support, at least in this session that you have been providing. All right, thank you, and have a good day.
Thank you. Thank you. And Varun, if you could send me the questions before you log off, if you can copy and send me the questions, because as I said, we are collating all the questions as well. Yeah.
Sure.
All right.
Okay. Thanks, Ashish. Thanks, Priyanshi and Varun. Bye.
Thanks.
Yeah,
Bye.
bye.
Thank you. Bye.